will have 15 minutes to present oral argument. Appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time, please let me know as I'll be keeping time.
Thank you.
We're ready to proceed when you are.
Thank you. And please, the court, I would appreciate the ability to stay 5 minutes.
Sure.
May it please this court, my name is Frank Semino, and I'm here on behalf of the appellant, defendant, Mr. Schuler. He's here obviously on behalf of the plaintiff. This is a loan that existed began back in October of 2004 with previous someone prior to Citizens, Charter One Bank. And there was a loan taken out by the branch road in the name solely of that partnership, that limited liability company, and I believe Ms. Schmidt is the one who executed the document. The payments were made in a very faithful manner throughout the course of the loan. However, there was a point where apparently Ms. Schmidt did not provide financial statements sometime during about 8 years into the loan. And as a result of that, the bank took that as a default and moved forward and imposed that in February of 2015. And the payments, again, were continued to be made under the amount that had been set forth in the note. And I guess one thing that I'm concerned about in that is that if you look to the term loan, and that's my Exhibit A in my brief, in the very first paragraph at the end, it indicates that the borrower shall pay consecutive monthly installments of principal and interest as follows: $1,721.40 on November the 4th, 2004, and the same amount, in parentheses, except the last installment which shall be in the unpaid balance on the 4th day of each month thereafter. And it talks about principal or interest at 5.99%. The other, and that's on page 1 of the term note of Exhibit A. On page 3 of the term note, I believe that's where it sets forth what the default provisions are. And I believe in the last paragraph, full paragraph on that page 3 of the term note, it indicates that upon the occurrence and during the continuance of an event of default, interest shall accrue at a rate per annum equal to aggregate of 5% plus the rate provided for herein. And then it talks about if any payment is not made, there will be a 10% interest that will be charged on that basis. I guess the concern that I have is that there is this email from Ms. Lawson in November of 2013 that indicates that they had made a mistake as far as how they had calculated it. And they wanted to raise the monthly payment from the $1,721.40 to approximately $2,470 per month. I don't believe they had the ability to do that. I think that's contrary to what the note says and what the remedies for the bank are. I think they could certainly raise the rate to 10.99%, no question about it. But as far as raising the total monthly payment, I don't believe that there was authority for that. I think that you'll see that, unfortunately, because there isn't all the evidence before you, there were conversations between Ms. Lawson and my client, Mr. Shane Ward, and he was saying, I don't understand how you came up with this amount. This doesn't seem to be appropriate to me. And I have emails that, I would indicate to you that Ms. Lawson gets back, and she indicates on December the 19th of 2013, I wasn't made aware of what the payment would be and how it was calculated. It may be calculated based upon the remaining amortization of the loan. I have put in a research request to see how they came up with the payment. I'll let you know. And then she subsequently refers back to him and says, and this is on January 9th, 2014, Happy New Year to you. I'm sorry for the delay. I sent numerous follow-up requests to find out how the new payment was calculated with no response. I'm going to escalate the issue at this time. And then she goes back to, as previously indicated, the way the payment was calculated previously was incorrect, as the payment remained the same and the interest amount increased and the principal correct way to calculate the new payment was to use the newest interest rate and re-amortize the balance. The problem that I have with that is that the remedies under the note on page 3 do not talk about the bank being able to re-amortize the note. It's simply a straight payment of $1721.40 for the 10-year time period, well, for up to the last month, and then the last payment is supposed to be the balance of everything that was to be paid on the note at that time. And it's,
Well, how does that address the default interest provision?
it addresses it, Your Honor, that when the bank went from $1721.40 per month as a payment and raised it up to $24.70, I believe, that, I don't believe they had the authority to do that. Under the terms of
But my
the-
question is, you don't believe they had the authority to do that, but what is your position that by their not having the authority to do that, that is writing out of the loan agreement the default interest rate?
Well, I'm not arguing that the default interest rate doesn't apply.
How do they recapture that?
Well, I mean, to me, what would have been done would be, if you look at the exhibits for Mr. Fournier, he indicates on both his exhibit, I believe it was July 30th, 2015, and his exhibit of September the 25th, 2013. He has the balance sheets, or the spreadsheets, dealing with what the payments are. On July the 30th, 2015, he begins in, I think it's July of 2013, no. Well, it goes up to July of 2013. And what he's indicating is and this is a different issue, the principal, there was 8 months of payments that have been made, starting in October of 2004. In July of 2005, on his spreadsheet, that's where he begins in his spreadsheet for his affidavit of July the 30th, 2015. But we're talking now about the fact that the note was in 2004. His spreadsheet begins in July of 2005. He shows $7,500 worth of interest being calculated or accrued. The total payments are somewhere in the neighborhood of $13,000 some odd dollars. He's showing on his spreadsheet beginning in July of 2005 that there was a balance of $264,000. Well, if you subtract the total payments made, you'll see that there's $5,000 that would have been applied to principal. He's indicating in his affidavit spreadsheet that it's $264,000 that's left on that obligation. In reality, if you start with the $267,000 that was borrowed, and you subtract the $5,800 that would have been left for principal, it would have been down to $261,000.
But I understood his position to be that because of the default interest rate, that the $5,000 did not go to principal because the interest rate had increased and the payments were not addressing all of the interest rates after the default.
Well, what I'm indicating to the court, though, is that this is many years prior to that. I appreciate what you're indicating as far as the point in time in 2013, when February 2013, when they indicated they wanted to go to the default interest rate. I'm talking back in 2004,
Oh, back at the early
when the
stages.
note was first done, up through July of 2005, and I'm saying there is a discrepancy. And if you look at his spreadsheet of attached to his affidavit of July of 2015, which refers back to the time period, and I apologize for the confusion on this, the time period from November the 4th of 2004 through up until July of 2005, there's a statement there as of accrued interest. It says $7,900. The payments are listed, the payments that would have been made, because every payment was made, there would have been an extra $5,800 that should have been applied to principal. But when you look at that spreadsheet, you see that there was only, instead it says $64,000. Well, if you started with the $67,000 as a loan and you subtract the $5,800, it should be down to $261,000 and some dollars. I mean, I think it's, set forth in the brief, but, that's the concern that we have as far as the initial spreadsheet, that was done in this matter. In relation to.
Let me just interrupt, because you had asked to reserve 5 minutes for
Yes.
rebuttal, and you're encroaching now on your
You-
rebuttal time.
The only other thing I want to raise for a second is, I know that I just initially appealed on behalf of Mr. Shane Ward. I would appreciate being given the opportunity to forward a written motion to include Branch Road as an additional party to the appeal. But that would be something that, I did not appeal on both parties, I only appealed on one.
Yeah,
So I might submit it to the court for your evaluation.
thank you.
Good morning, Your Honors. Chris Schuler for the appellee. There were 3 arguments raised before the lower court to defeat summary judgment, and all of the arguments failed. They are, number 1, they challenged the calculation of the balance owed. Number 2, they challenged the bank's standing. And number 3, they argued that because there are cross-claims pending, that the lower court should not have issued summary judgment until the cross-claims were resolved. I'll address those in order. On the balance owed, there's no dispute as to the defaults at all. There's no dispute that Ms. Schmidt failed to provide the required financial information in 2012. And significantly here, this loan matured 2 years ago, October 4th, 2014. So there are certain defaults here. All the payment records are before the court. They accurately reflect the balance owed.
To that point, what about the point that is made in the appellant's brief that the account begins several months after the loan was entered into, some 8 months as I recall?
That I can't speak to, Judge. I don't know. I don't have an answer for you on that. But I do know this, that the defendant and the appellant has not provided an alternative calculation, which I think they have the burden to do. And instead, they've kind of made these vague comments, even new comments today, that I honestly, I'm not sure I follow, but again, they don't lead to some punchline where they say, here's the correct calculation, and I think they have the burden to do that to defeat summary judgment. There's also no allegation here that the bank missed any payments in its payment history. So it's not as if we failed to account for all of the payments. I think this is a straight math analysis, and it's done by a computer, and I think it's before the court, and I believe that we've met our burden on that issue. There's, in their papers, the appellant talks about this email where there was a billing issue raised, but again, that doesn't deal with the payment history, it's a billing issue. And I think it was pretty clear from the exchange that the bank was saying, hey, we actually we underbilled you, and now we're going to kick it up to the correct billing amount. But at the end of the day, it's the payment history that governs the correct balance that's owed. On the standing issue, counsel, maybe he's abandoning that argument, I don't know, but we have a sworn affidavit that the appellee is the successor by merger. We also have numerous public records that we put in to the pleading, so I really don't think there can be a dispute that we have standing. And then on the cross-claim issue, I think the case law is pretty clear that a court has the ability to issue a final ruling as to some parties but not others. And that's the conclusion of my presentation. I'm happy to address any questions of the court.
Apparently there are none.
Thank you.
So you have about 4 minutes remaining for rebuttal.
And please, this court counsel. Your Honor, as far as the underbilling is concerned, that relates back to my concerns regarding page 1 of the term note, page 3 of the term note. The order, or the note, terms of the agreement were $1,721.40 a month until you got to the balloon payment and you did it there. There's nothing in that term and/or in the default provisions on page 3 of the term note that allow them to do what they did.
So to your way of thinking.
Your Honor, just to make sure, I'm not arguing the fact that the default interest rate does not apply. I have no problem with that. But they don't have the ability to kick up the amount of money that you're supposed to pay on a monthly basis. When they say they made inaccurate billing or whatever, the billings should be $1,721.40 per month for the full 10-year, except for the last month, where the total balance was to be paid.
And then that total balance, to your way of thinking, would include the increased interest rate.
Right. When you look at the balance sheets that they have, or the spreadsheets that they have, you know, it's interesting, or somewhat unusual, but supposedly interest is accruing, but the principal balance never increases. So if we owe money, we don't have any problem with that principal balance increasing pursuant to whatever the interest added to, the accrued interest is. But it doesn't, it always stays the same when you get to July of 2014, I'm sorry, February of 2014. If you look at those spreadsheets, it doesn't increase, the principal doesn't increase, it stays the same. And they're still saying that, but you're supposed to be paying us $24.70 or whatever it is on a monthly basis. And I believe that, you know, it just doesn't seem to flow properly. It doesn't seem to, you know, make sense. And I guess my concern about, you know, Ms. Lawson is that she did say these things are inaccurate. She then says, what's so troubling to me is I can't tell you how we calculate it. We try to make the principal the same amount as it has been, your payment on principal. Well, if you look through the loan, you know, a lesser amount was paid on principal in the beginning, and a greater amount was paid toward the end. So how you say that you're trying to make your principal payment be the same as you had been paying, you know, it seems to me, what principle are you talking about? What provisions in that default portion of the term note permit that to be done? I don't think there are any. And the wording is pretty clear. They have a right to charge the default interest, fine. But going about changing how the loan is to be paid off, I believe is inaccurate. And it's not,
that, the default interest, does that accumulate in, it's not paid, so that then becomes part of the principal that's owed upon which the interest is calculated.
right. And just so you understand, Your Honor, they are continuing to pay the $1721.40 on a monthly basis. At one point, they in fact make, because then they're going back and forth, what's the right payment, how much do you pay? And I can't tell you, but they just start paying the $24.70. So there's about 6 months of that. And then Ms. Schmidt submits her financials and they drop it back down to $1721.40.
So when does the loan expire? Is there a lump sum due
There
at
was
the
a 10-year,
end, or is it extended until they can pay off?
No, it was a balloon payment at the end of the
Okay.
10-year time period. So it was all, everything was to be
So
paid.
that balloon payment would change depending on how they paid and what the rate was.
Yes.
Thank you.
And just one more question that I had. This argument that you're making about it being inappropriate for the bank to change or to add the higher interest rates before the balloon payment, was that advanced in your response to the motion for summary judgment?
Just to clarify, Your Honor, I'm not indicating, I appreciate the idea that once there's a default, I'm not arguing that when Mrs. Schmidt failed to provide her financials, that was a default. And they implemented that in February of 2014. And they had every right to charge not only the initial 5.99%, but the additional 5% for the default, bringing it up to 10.99.
Right.
So they had no difficulty, I'm not challenging that at all. They have the ability to do that. What I am saying, though, is I don't believe the term note that's part of the exhibits that I presented in my brief allows that to happen, because there's the initial statement that says, look, here's what you have, Mr. Shane Ward, a payment of $1,721.40 a month until your very last payment when you're supposed to pay off the balance. That's the terms they entered into. There is no question that on the default portion on page 3, listen, if you fail to do that, we're going to start charging you not only the initial 5.99, but an additional 5%. And so that interest is going to be accumulating on whatever your balance is, and I don't have any problem with I don't believe they have the ability to step in and tell him that, okay, you now have to, we're gonna start changing this, and in one of the emails she sent says we're gonna re-amortize the loan. The default provision on page 3 does not include anything like that.
And
You can
but
charge-
my question is, specific question is, whether or not that argument was advanced in your memorandum contra the motion for summary judgment, so that that specific issue was before the court when it ruled on the motion for summary judgment.
You know, and I was not the attorney at that point in time, so I honestly don't have the ability to answer that question.
All right, well, we'll obviously look at it, and you've reached the end of your time.
Thank you.
Can I have 30 seconds, Your Honor?
No, only because, you know, there's no way for you to respond. There's the appellant, and then you have your time, and then rebuttal for the appellant, but not for the applicant. Thank you.